Okay, so last day of the judicial branch chapter, and this really does lead in, just like last lesson did, lead into the civil rights and civil liberties chapter for us. So, Griswold v. Connecticut, the justices find the right to privacy to use contraceptives. Now, there's a case, in the early 70s, I think it was in 72, Eisenstadt v. Bard, where they're going to extend the right to use contraceptives to unmarried couples. So this was just for married couples. And then you have the Roe v. Wade case. So the big thing with Griswold was that nobody really cared. I don't know if anybody in 1965 decided in 66 cared that the justice found a right to use privacy in terms of contraceptives. But what a lot of people were worried about, the conservative people, is they were worried that they were like, wow, if they find the right to use contraceptives, are they going to find the right to have an abortion? So it was really, to some people, opening up a sort of a Pandora's box, a slippery slope, that one thing would lead to the next. And so Griswold v. Connecticut, one of the most landmark cases ever, with the right to privacy. Then Roe v. Wade comes up. And in Roe v. Wade, they basically were trying to decide if laws were valid, if they were constitutional, if they banned abortions. And the court upholds a woman's right to choose. So they invalidate laws in a lot of states that were limiting abortion. And in that, they create what's called the trimester framework. Now, the trimester framework is basically what they do is so this is trimesters. Now they're going to create this in the decision. And they're going to take the pregnancy and they're going to break it down into chunks. The judges are. So the second 3 months, and I know it's hard to read my writing, but you get the point. So they're going to break down the pregnancy, the 9-month pregnancy, into three-month chunks. And they're going to say that basically when it comes to a woman's right to choose, in that first 3 months, there can be no limits at all. In the very last 3 months, they can ban. They can extremely limit abortion in that last one. The second 3 months is where it's a little bit of a gray area. This is what they're going to say in Roe v. Wade. So what happens is the court comes up with makes a decision. When it comes to abortion, everybody's view, really, I think almost every person's view on what they feel personally about abortion would come down to when they believe life begins. Now, what the court decided was it believes it begins at the beginning of the third trimester. So what they did is they basically went like this, and they said that what they're most concerned with is the mom or the pregnant woman here. That's who has rights. In the second 3 months, it's the mom, but we have to, as a society, be aware that there is a developing person in there. In the third 3 months, you are now basically concerned with two people in a way. So they're saying that after those first 6 months, now you have two citizens almost that we have to be concerned with. So, but in the first 3 months, it is just the one person, and it's her body and her choice. Okay, so this is what happens with the trimester framework. Now, when it comes to the outcry, you have two parts of this. Well, first, the side that was in favor of it, they claimed it was a win for women's rights and for personal freedoms and the right to privacy. The other side, you kind of had two different parties on the other side. You have the social conservatives, and still do, who just believe abortion is murder, right? And they don't want this to happen. Then you have the constitutional conservatives, who abortion isn't so much their issue, but what they don't like is the court was showing judicial activism to an extreme here, because we think of courts as saying yes or no. Guilty, innocent, or guilty, not guilty, or constitutional, not constitutional. So the court in this case said laws stopping abortion in the first 3 months are unconstitutional, right? And that, for some people, would have been okay. But then they go further and they go, not only are they unconstitutional, but we're going to take the 9-month pregnancy and we're going to break it down. We're going to say, they're going to spell out regulations and rules. So basically, the court is going to make a law that everybody has to follow, this trimester framework. So a lot of people are really bothered by that. But it's hard to get past the sort of debate on moral or immoral, or a woman's body versus two people, and that's where a lot of us get hung up, is because it's a very passionate subject. But there is the constitutional side of this too. Now, Planned Parenthood v. Casey in 1992, when this comes up, this actually is going to break down the trimester framework. It's sort of a conservative, it is a conservative decision, going to make liberals upset. So the trimester framework doesn't really exist anymore. In Planned Parenthood v. Casey, the court is going to look at some rules that were put in place in the very beginning of the pregnancy, in the first 3 months. Now, in Roe v. Wade, it said no limits at all. A woman just has the right to choose for any reason. It's her choice the first 3 months. By the time 1992 comes about, the court says, well, you know what, we'll allow some things, some restrictions in the first 3 months, if those restrictions don't place an undue burden on a woman's right to choose to have an abortion. But then the obvious question is, what is an undue burden? All right, and that's just different for different people. And so, there are many different things. In this case, is it an undue burden if you make a woman get consult with 2 doctors before having an abortion? And the court basically goes, no. It's an undue burden if you make a woman wait 24 or 48 hours, or she goes and meets with a doctor, has to wait till she comes back and has an abortion. The court says no. Now, to some people, both those are undue burdens. It's an undue burden if you make a minor get parental consent to have an abortion. Now, the court said no. And they said that they allowed a process called judicial bypass if maybe the parents are abusive or something like that. The girl couldn't go to the parents, but they say that's fine. And again, some people may say that's not right. If you're a pregnant one female, then you should be able to make the choice. And then one came up that was called spousal notification, that a woman the law said had to at least notify her husband she was going to get an abortion. And same type of thing where there was a judicial bypass. If maybe the husband was abusive, then there was a way to go to a judge and go around. But just the concept that a woman had to tell her husband she was going to get an abortion. And the court said in this case that was an undue burden. So they got rid of that. And again, you could argue that all day. But so the point, though, is what the court allows restrictions in the first 3 months, and they break down Roe v. Wade a little bit, upset a lot of the people who are on the pro-choice side and, in some people's mind, women's rights side. So anyway, the trimester framework doesn't exactly exist anymore. Then you had people who are like, well, boy, what's happening is we allowed contraceptives for married couples. Then we allowed contraceptives for unmarried couples. Then we allowed a woman to have an abortion. Now we're going to have to start allowing, gay people to have certain rights. That was, way more radical 30 years or 40 years ago than it is now. But so in Bowers v. Hardwick, they actually kind of backtracked on all the rights of privacy they'd been giving out, and they did not give it to homosexuals. They actually allowed laws to be different for heterosexuals and homosexuals on certain intimate activity. We'll skip Romero v. Evans, but in Lawrence v. Texas, they, in a lot of people's minds, righted or wrong. They basically said, no, that's crazy. What they did is they said in Lawrence v. Texas that if there was some law about intimate activity between 2 people, it had to be the same for everybody. It couldn't be different for heterosexuals and homosexuals. And when that happened, a lot of states went through and realized they had probably pretty dumb laws on the books, and they went through and got rid of some of those laws, or at least balanced them out so that they were equal for everyone. So the big ones to know, obviously, though, are Griswold v. Connecticut, right to privacy from yesterday, Roe v. Wade, a woman's right to have an abortion, and even Planned Parenthood with the undue burden test. Now, jumping to Roe, I'm not going to harp on this, but they do find the right to privacy again. You can see in the first paragraph they mention a personal right to privacy protected by the 1st, 4th, 5th, 9th, 14th. And then at the very bottom there's part of the decision. And then the other one, Planned Parenthood. So it's something that I was talking about, the question there in the middle. Can a state require women who want an abortion to obtain informed consent, wait 24 hours, if married, notify husbands of minors? And so it says in a bitter 5-4 decision, the court again reaffirmed Roe, but they said that yes, a woman has the right to choose, but it upheld most of those parts of the law, of Pennsylvania's law. So for the first time, justices imposed a new standard to determine the validity of laws restricting abortions. The new standard asks whether a state abortion regulation has the purpose or effect of imposing an undue burden, which is defined as a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. So they, like I said, they do break down Roe a little bit, but we now have, through a series of cases, we now consider that we have the right to privacy because of cases like Griswold v. Connecticut and Roe v. Wade and several of the homosexual cases that have come up in the last 20 years or so. So I will stop there and wrap up the judicial branch chapter. Thank you.